Transport Minister Barbara Creecy has called on the Road Accident Fund Board to come up with a plan to decrease the backlog of cases currently clogging the court roll in the Gauteng division of the High Court. The Daily Maverick reports that the Transport Minister and her deputy, Gauteng, met members of the legal fraternity and the RAF board separately in the hope of finding a solution. McIntosh Polela is the RAF spokesperson and joins me now. Very good afternoon to you, McIntosh. Thanks very much for your time. Before we get to those issues about court management of the court cases and all of that. Now, apparently you finalized 63,015 claims from 79,377 that were registered last year. And I was asking myself, what happened to the 16,352 cases?
Yeah, so the nature of claims is obviously we aim to finalize the claims within 120 days. And so, in other words, we receive the claims, and when we receive the full complements of documents, we are able to then analyze those claims and make an offer. And mostly those are the claims that have been finalized, where the claimants have said we're happy with the offers, obviously through their lawyers, because 97% of our claims are represented by lawyers and only 3% do the claimants come forward. So the ones that you were asking about, the more than 16,000, it could be the cases that obviously the lawyers are not happy with the settlements and they decide to go the route of the court. Now, many of our claims, and tens of thousands of them, go through that route of the court, and hence we are not able to finalize them.
Now, previously, you've had a panel of attorneys, right, who would act on your behalf in the courts, but that has since changed. You now rely on the State Office of the State Attorney to represent the fund. Has this made a difference?
Look, it has made a difference in terms of saving the RAF a lot of money, and I'm talking about billions of rand and monies that could have been paid to lawyers, which we now pay to the claimants. But what has happened as a result of that is some of the same lawyers that used to work for us, obviously, having lost income that way, are inundating us with, your court cases. They're issuing summons. We receive summons practically every week from those lawyers, and sometimes after going to court, they attempt to attach our furniture and our properties. So yes, it has made a difference in that we have transferred the monies that used to go to the lawyers to the claimants, who are the people that deserve these monies. But the downside of that is obviously the lawyers are suing us left, right, and center. The cases that should be going to, an amicable solution by way of settlements are now being dragged to the courts unnecessarily, and most of them end up being settled in any case on the steps or the corridors of the courts, because they should never have gone to court in the first place.
Is it a question of them clogging your system to make you look incompetent or incapable, or is it a question of not having adequate numbers of people who are able to deal with these summons as the fund?
You must understand that for the summons to be valid, not necessarily to be valid, for the summons to be able to be dealt with, we must see these these summons on time. But it never happens. We have summons that are supposed to be at the desk of the CO that the CO has not seen, that were sent, for instance, last year, the year before last year. It is a deliberate strategy to make sure that you inundate the CO with these summons, but he never gets to see them. When he gets to see them, it's too late. I mean, there are other processes that have already gone into the court. Now, you're talking about the issue of clogging the court. You must understand that the RAF doesn't take itself to the court. We are a plaintiff in the court, and
no, saying clogging your system. Now, I was saying clogging your system. In other words, you have to respond to loads and loads of summonses, and you don't have the capability to do that. And my question was whether you think these lawyers were doing this deliberately because of that past, so that you don't, I mean, your hands are full.
It's a deliberate strategy to make sure that we have our hands almost tied dealing with these many summons. But it would be helpful if these summons came and the office of the CEO was able to see them. I mean, the lawyers have gone to the extent of sending summons to his house, which is in itself something that is not good, because they know the address of the RAF, and they sent these summons to the regions. And by the time the regions send these summons, the dates at which these summons have to be defended have already gone past. And so they're playing a kind of dirty game in that they could just easily send all these summons straight to Eco Park, where we have our offices. But we get them going all over his house, the regions, where it's going to take time to reach the office. A deliberate strategy so that they are delayed, so that they're not defended on time.
Now, the impact of that, according to the Gauteng Judge President Danson Mlambo, is that now you have judges having to deal with hundreds of default judgments each week. And from where they are sitting, it is because you guys are ignoring the summons. Now, you have just told me
exactly what I was saying to you.
Yes.
It seems to the Honorable Judge President that we are ignoring the summons, but we're not. It's just that we never get them on time. We've got months and months that have gone past with some of the summons, almost a year with some of them, and you get them piling up at the office of the CEO, but most of them, their date has already passed. And so to the Honorable Judge, no, we're not ignoring them. We just don't get them on time.
Now, the members of the executive are obviously concerned about this. They also have to listen to the plea by the Gauteng Judge President, Judge Mlambo. Have you found a solution, or are you on your way there? What have you promised the Minister and Deputy Minister is the way we are going to help deal with not only this problem, of course, but also the one of the turnaround, because that too has its own consequences for the fund. The fact that you have to deal with the thousands of cases you have to deal with every year, but you also still have to deal with the backlog issues. What have you put on the table as a way of dealing with both these two key issues?
So first of all, in dealing with the backlog, we went on a campaign earlier this year where we've said we have over 300,000 cases in our books, and of those, we have segmented over 200,000 of them as being part of the backlog because they were lodged before the year 2021 in April. And we've said to people, please come forward. We want to settle these claims to make sure that we pay them out to you. Because for us, it's of no interest to be seating with them. Now, when it comes to the issue that has been raised by the Honorable, Judge President of the North Gauteng High Court, we obviously have, sat down with different stakeholders that are relevant to this. And one of the issues that we have suggested was that we have a road accident fund adjudicator. In other words, a standing office that will be able to judge, whether the claims are worth settling or the others need to go to court if the lawyers or their claimants are not happy. So we've put forward different solutions. And as you know, we have the Amendment Bill of 2023, where we suggested a lot of things. And amongst them that, we have this adjudicator who will be able to be solely responsible for the cases of the Road Accident Fund, because there are many of them, and it is important for us to pay the claimants and to pay them timeously and speedily.
Speaking of, paying claimants, there was something that caught my attention, what has been referred to as general damages, right? And you have the CEO, Colin, saying he also doesn't know what this is, and he thinks it's being abused by lawyers. He reckons it's some kind of a sorry money that the fund has to pay to lawyers. I mean, if you of all people don't know, what this is supposed to be, then who should know, and why are you paying it?
It's the lawyers that know. You must remember that the law was written by lawyers for lawyers. The other argument that we have is that this is a social benefit, and I'm sure you heard the CEO today saying it is very strange that a social benefit has to be accessed by way of dillet. In other words, you have to go to lawyers to be able to access the social benefit. And he was asked by one of the reporters, "What do you want to do?" And he said, rightly gave an example of SASSA to say people are able to claim a social benefit at SASSA without the assistance of the lawyers. And likewise, when you come to NFSAS, you are able to claim the social benefit without the interference of the lawyers. This used to be an insurance, as you know, until 1986 that was run by the private sector. It has run into so many problems. It's still running into problems. And with the Amendment Bill of 2023, we're saying, here's a solution. Kick out the lawyers, have this adjudicator, and it should be okay. We should be able to solve these many problems. And the complaint by the Judge President that we are clogging the court, that will be done away with.